All right, good afternoon, everyone. I am going to call to order the meeting of the Sentencing Guidelines Commission. Today is October 9th, 2025, and I will ask our director.
Roll call, Vice Chair Larkin.
Present.
Larkin present, Commissioner Castro.
Present.
Castro present, Commissioner Fraze. Fraze present, Commissioner Keefe. Keefe absent, Commissioner Ladd.
Present.
Ladd present, Commissioner Mazzaros.
Present.
Mazzaros present, Commissioner Middlebrook.
Present.
Middlebrook present, Commissioner Moore. Moore absent, Commissioner Moran. Moran absent, Commissioner Mueller.
Present.
Mueller present, Commissioner Reeves.
Present.
Present, Commissioner Saxena. Saxena absent, Chair Mitchell.
Here.
Chair Mitchell present.
You.
Checking here. Madam Chair, there are 9 members present, 4 members absent.
So that we have a quorum. Next item is approval of the agenda. So I would entertain a motion to. So move.
Second.
Commissioner Reeves, seconds. Do we have any discussion on the agenda? Hearing none, we'll take a vote.
Do the Larkin motion to adopt the agenda. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze?
Yes.
Fraze, yes. Keefe? Keefe absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore? Moore absent. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Yes. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
And with that, the agenda is approved unanimously. Next is the approval of the draft meeting minutes from September 11th. You should have all received them in advance. I would entertain a motion to approve the minutes. Second. Commissioner Larkin, seconds. Any discussion on the minutes? None. We'll take a vote.
To the Middlebrook motion to approve the September 11th meeting minutes. Larkin?
Yes.
Larkin, yes. Castro?
Yes.
Castro, yes. Fraze?
Yes.
Fraze, yes. Keefe? Keefe absent. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore? Moore absent. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena? Saxena absent. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, no votes opposed.
All right. Sorry, what I am delaying on is the next item is related to the language for the first offender departure factor, talking about the case law discussion that we had last week. I'm kind of hesitant to enter into that conversation right now, though, however, because Justice is not here. He's on his way. So, or at least he's potentially coming. So I'm wondering if you wouldn't mind delaying a little bit. Do you have an executive director report we could just pop
Sure.
in instead?
I could, and I should just note that I found Commissioner Keefe in the attendees and elevated her to panelists. So she presumably is in the meeting now, but was merely an attendee prior to now.
Thank you so much for doing that. I appreciate it.
Sure.
Good to have you here.
So, Madam Chair, I have a few items for the Executive Director's report. One item, well, first of all, we were pleased to announce that beginning October 23rd, MSGC staff will begin holding monthly lunch and learn webinars. No advance registration is required, all are welcome, and for lawyers, CLE credit is planned. So dates and access links are available on the website under Education and Training, Training Calendar. Speaking of the website, staff have redesigned the website to provide better user experience. I don't know if anybody's been on the website in the last couple of weeks, but if you have, you probably noticed a number of different changes and for me, I'm the acid test is, am I still able to find what I need? And I've always been able to find what I need. So they did a good job of reorganizing it, mostly Katie on that. We've, in addition to the navigation and visuals that have been improved, we've added 2 new sections, a comprehensive review section to keep everyone up to date with information concerning the comprehensive review, and a data library section where users can find the data they need quickly with our new easy to search data archive. So please check out the website. I guess the other thing I was going to announce is that the November meeting will take place 4 weeks from now, November 6th. So that 4 weeks is the regular time interval, but no, November 6th is a little early in the month. So just want people to keep that in mind, that that's a little bit earlier than you might anticipate. And that meeting will take place in this building. I have another announcement pertaining to a public hearing that was contingent on the commission's action today, so I won't get into that. For those who knew, and I know it's a smaller group at this point, but for those who knew Judge Warnick, details of his memorial service have been announced. He was a commission member. Earlier on, he was a public member, but if anybody's interested in information about that memorial service, please see me after the meeting. For now, concludes my report. There'd just be some logistics on a public hearing that turned out to be necessary, and just and I guess I could talk about that too. If so, we're at a process right now where the commission could, if it wanted to, take action. These are all items that have been discussed and brought before the commission in the past. Not necessarily with respect to the legislative recommendations. That doesn't require going to a public hearing, so that's something that could be delayed. Something that we typically put in the January report to the legislature, but we have some time to tweak that, finesse that. But as far as the changes to the sentencing guidelines, if the commission felt comfortable with this, and all these changes are things that we've talked about for several meetings now, it could preliminarily adopt them. But just to be clear, that is a preliminary adoption. It's not final until after a public hearing has occurred and the commission meets one more time, considers everything that they've heard from the public, and then takes final action to adopt or not to adopt, or adopt in a different form the proposed changes to the sentencing guidelines. And then those would go in the January 15th report to the legislature. The legislature would have the entire session to think about them, debate them if they want to, possibly block them with the law. But if they didn't block them with the law, then those guidelines would go into effect. Those changes, I should say, would go into effect August 1st. So that's kind of the road forward here. This is not the last chance to adopt this hearing package. You could also do it at the well. If you did it at the November meeting, then the December meeting would have to double as a commission meeting and a public hearing. So that would be just one downside of doing it, waiting to take final action. But it could happen. Questions about logistics?
Commissioner.
And not a
Larkin.
question, but just, I speak in favor of taking action today. I've been on the commission for 6 years. And this is the first time we've ever been this far ahead of the game. And it seems like we've had a lot of agreement. We have a good plan going forward. I mean, just typically, we're scrambling in December and then we get to that January meeting and we're trying to incorporate public comments, make sure we're still okay with it, and do our legislative report. It's really a grind. So I speak in favor of that, just so we can take care of the proposal, the hearing, our changes, and really dedicate January to the legislative report and give it the time and attention it needs.
And it certainly would work better for staff for those very reasons.
Nice break over the holidays.
Well,
Most
and,
people normally do.
and I should, another consideration if we're looking far ahead is the January meeting is only 3 weeks after the December meeting, really close. And it's also, needless to say, there are 2 major holidays in that 3-week period. So it's possible that we might want to consider, and I haven't talked to you about this, Madam Chair, but it's possible to consider maybe a remote meeting or just like a single subject meeting in January, because staff is going to have a hard time preparing for that meeting and preparing for the December meeting before that. So I think it would be very doable to make any final edits to the commission report to the legislature prior to the January meeting. And maybe that's all we could hope to do in the January meeting. Possibly would just be to finalize the report to the legislature. But that'd be really nice if the commission could take final action at the December meeting on proposed changes to the sentencing guideline. Then we could do all that very time consuming write-up, putting all that in the report to the legislature. We can have all that prepared in advance, and I think the January meeting could go pretty slick.
Great, so is it Commissioner? Well, let's go ahead and go on to item 4, which is adoption of language from the first offender. I can do it.
Up to you. Way to display that.
Yeah, that'd be great. So when we brought forth the proposals from the steering committee at the August meeting, we mentioned that there was one item in there that had not received full support of the steering committee, but we also hadn't had enough time to really talk it through. And that was to think about putting some language in the guidelines that evinced the commission's intent that there would not be a divide in how durational and dispositional departures could be supported. Right now, under case law, there is a division of case law that basically says that dispositional departures have to be based on factors that relate to the individuals, and departures have to be based on factors that relate to the offense itself, the seriousness. And yet, as we discussed, what some of the high departure rates might be driven by, we talked about the fact that there are instances where there might be room to cross that line, and that we have a lot of dispositional departures, which means that most frequently mitigated dispositional departures, meaning that the person is recommended for a prison sentence under the guidelines, but is getting a probation sentence instead, and that perhaps there are situations where that prison sentence really is the right sentence, but the duration that we have the guidelines isn't isn't, may not feel appropriate by many of the parties involved because of certain characteristics of the individual. Age was talked about. So we had brought forth the idea to maybe we break down those barriers and give a little bit more flexibility. And within the commission, we had a robust discussion about that and about the concerns about overturning a long tradition of case law and so this month, the intent was to bring forward case law. See that as well as a few other pieces of information to give the commission more to think about. And the case law is it's really complex. It's not, so I explained it very simply, it's not that simple. There are a couple of different, left turns in the way the case law is written. And really there are, if you sort of go departure reason by departure reason, there might be different answers. So it just got to the point where if we were to really try to understand how all of that works together, it would take much more for us to map that out and bring it to the commission in a meaningful way so that we could have a good discussion. So I am feeling that we have a pretty good package and that we have a lot of agreement with the elements of the package. I didn't think that was that we had enough time to really to go through that, and that we shouldn't hold up the rest of it for that. So I made the decision to pull that piece out, but this factor, it affects this factor, because one of the proposals was to add a new departure factor, saying that if the person truly had no prior criminal record, that not even just a criminal history score of 0, because you could have some priors and still get a score of 0. Truly, this is your first offense, that that might be a factor that would support a departure. But without thinking about if that divide exists, then it wouldn't have applied to duration departures. So what I'm proposing here is that for this factor, we add commission intent, that it could be used to support both a dispositional and a duration. So that's the sort of modification to the proposal that I'm putting forward for consideration and discussion. I'd open it up for discussion. Commissioner.
Just to be clear, when we say no prior criminal conviction or stay of adjudication, that includes misdemeanors. It includes also juvenile adjudications. It does not.
Why don't,
So if you have prior juvenile adjudication,
We're not,
right, they wouldn't be convictions. That's why I'm asking. So, all right.
correct, yeah, not you.
The answer.
Madam Chair,
Yeah.
I mean, just to be clear, that was a two-part question. So I think just so the record is clear, my understanding is the answer to the first part of the question is misdemeanor conviction is a criminal conviction. So that would qualify, or I should say that would disqualify somebody from this departure factor. But a juvenile adjudication of guilt is not a conviction unless it's accompanied by EJJ conviction. And therefore, a juvenile adjudication of guilt by itself would not disqualify somebody from this departure factor.
I just wanted to get clarification.
Commissioner Larkin.
and following up on that, you raise a good point, because as I understand that this is not like, okay, you automatically get a departure, right? This is
Correct.
something, so a judge could look at this and say, well, yeah, technically you have nothing in adult court, but I'm looking at your juvenile record and I'm not seeing substantial and compelling reasons to apply this factor. So I think it could influence the decision.
Because my thought, you get an aggravated robbery when you're 17, and for some reason it just stays an adjudication, and then at 18, you get something else. It's not the kind of.
Yeah, and so this is, I mean, that's a point well taken, Commissioner Larkin. This is this is adding a new factor to the list, right? So it's not, like, you're right, it's not automatic, it's something that you may do, you don't. I think you could. Commissioner Price?
I support the substance of this. I'm wondering whether the added language, qualifying cases as factor may support a dispositional or durational departure. Those are separate decisions, and in some cases, judges do both. Should it say and/or? With the intent that it can only be used for one or the other.
Lawyers.
So rather than and, it should, rather than or, it should be and.
Because again, if there are two separate decisions, the guidelines make that clear, and each requires a separate justification. If the separate justifications are met, then it would seem that unless there's something different about this departure.
As our Smith.
What's, I mean, I think there's a tradition of that the single factor cannot support two departures, right? So you can't base a durational and a dispositional departure both on,
But doesn't that presuppose this dichotomy that the committee was struggling with, that offender is only disposition, offense is only duration, and we're proposing to break that down. Which case, but I mean, the argument is a true first offender is less culpable, just as a lower criminal history is deemed to be less culpable. Separate from that, but just as important, a true first offender is assumed to be a lower risk.
yeah, I just don't.
It has to do with disposition, and culpability has to do with duration, by and large.
Commissioner.
You make a good point. I think in practice, I mean, in how many years, I've never seen somebody get both a downward dispositional and a downward durational departure. When there are multiples, I mean, what we usually see is, well, we're gonna give you a dispositional down and an upward
Yeah.
durational. I mean, so I just think in terms of practice, I just don't see that happening much. I appreciate, the academic point that, yeah,
I don't think it's
Step back.
academic.
Oh.
I mean, I think if somebody could commit an offense in a less serious than typical way, that makes them less culpable, makes the harm less. That seems to me justifies a lower duration, even if because of amenability, they're getting a downward dispositional departure, but they're often getting a suspended execution sentence. If they have to serve that sentence, the culpability side of that would say it should be a shorter sentence. And I don't know, I can't argue with whether you never see the cases in practice. I don't know why.
If the durational departure, though, was based on, well, somebody committed an offense in a less serious way, that would be a grounds for durational departure. And then you could say separately, never had anything before the court, so we're also gonna give a dispositional. So I suppose you could do that, but you would have two reasons.
So I think what I'm hearing is, if we have case law that says there can only be one reason per departure decision, this would not be able to be applied to both.
We also have case law that says offender factors, this is an offender factor, can't be used for duration. We're making an exception to them.
Right, right.
So, I mean, I don't want to derail things, I want to get through the agenda. It just seemed to me kind of a logical change, but, I'm guessing judges looking at that might not have to interpret it as either or.
Just for the layperson a little bit, so just to be clear, so this is an offender factor, but we're saying with the commission's intent, this would be a factor to be used on durational. departures as
It
well.
could be.
I just have a couple of wordsmithing
Yeah,
things.
for sure.
Should we say a criminal history score of 0 alone is not sufficient? We need to say that?
Not alone, because to me that means, like if you have a criminal history score of 0, the way it's written now, if you have a criminal history score of 0, you don't factor if you have a prior.
Okay, as long as that's clear. And
I
then
don't know.
do you need the phrase in qualifying cases? Because I read that, it's like, well, what do you mean by qualifying case? I assume you mean, a case in which somebody qualifies for this factor. Do you really need to say that? Can you simply just say this factor may support a dispositional or durational departure? Just simplify it?
Back and forth on that suggestion.
I mean, you may be lawyers, but these are the sort of things people bring up, and then we're like, oh, now we have to decide what
Yeah,
does in a
right.
qualifying case mean, and it just takes time and
I don't think
energy.
we need it. Take it out? All right, so we'll take that out. So it's just this factor may support a dispositional or duration departure.
We should probably have a dispositional or a durational departure. But we don't have to. Do we,
Yeah, go ahead.
do we need maybe something in the comments to say that we recognize there's a case law distinction between offender-related, offense-related? The committee is adopting this with the intent that this would be an exception to that rule. Just so it's clear. And just so it doesn't on its own suggest that all the case law that says otherwise no longer applies.
Madam Chair?
Yeah, Commissioner, Director Wright.
So from my perspective, I'm changing subjects here, but the whole custody status business, it was deleted from 2B2 and it was moved over to 2C2. And it was restructured and the commentary did not follow it. And I thought that it would make sense to work on the commentary at our leisure, if you will, after this is submitted to the report to the legislature. Because the commentary isn't part of the guidelines, so it doesn't have to be submitted in advance to the legislature. Something that could be done, say, in the spring, so that assuming everything goes through, it would all be published on August 1st. And this, I think we could also put in that boat if you wanted to work on a comment for this new departure factor at our leisure, if you will. It shouldn't really affect the public hearing. I think the public understands we're doing this.
So you're saying we have other comments we're gonna have to, we could take up the fact of whether.
Yeah, other comments that it would make sense for us to work on
Yeah.
in the spring.
That
So we
makes-
could just,
From a workload perspective. Mayor Ladd and then Commissioner Middlebrook.
Sorry, did you say me, Chair
Yes.
Mitchell?
Yes.
Okay, thank you. I've thought a lot about this. I was obviously part of those steering committee discussions, and I appreciate the effort to try to have maybe a gap filler as we sort of come back maybe a different time to revisit sort of the broader issue that was originally presented. And I still have some concerns and some hesitation with even this approach, because even with the discussion that we're having here, I just feel like we're starting to dip our toe back into the very things that created the problem for the original suggestion by the chair's proposal to address this. And so I guess I'm just wondering if there's wisdom in just not trying to do sort of this plan B to the first proposal, and we just really spend our time and effort on the original proposal after the first of the year next year when we're kind of over some of these other humps. And so that's my concern, and I don't know that I would be able to support this.
So Commissioner Ladd, this factor is in the package. Are you saying you don't even want this in even without this change, you don't even want it in the package?
Yeah, I'm just struggling with it. And I mean, we're wordsmithing it here, and I'm just even listening to Professor Frase's comments. I'm just kind of thinking my practitioner brain and some various scenarios, and I don't know. I still think I still think it's pretty muddy and still pretty messy related to the case law that's out there on this. And I understand the intention behind it, and I understand what we're trying to do, and even the reasons before it. And I recall Judge Knutson gave some really good examples when we were talking about sort of the want or the need to sort of do something different with some cases, and he felt like he couldn't because he couldn't consider certain factors because of how the case law is written on this issue. And so I don't know, I'm just putting it out there. I'm still sort of processing this, but I'm having some apprehension about it. And I just wanted to say that so that depending on how this goes, I didn't want anybody to be surprised if I vote for something that maybe I was sort of leaning into originally. So I just wanted to put that out there.
Commissioner Middlebrook, I think, was next.
Thank you, Madam Chair. Well, I guess I disagree with Commissioner Ladd on this. I mean, this came out of the steering committee, and I think Judge Knutson was one of the kind of the original speaker on this and what he found in his practice in sentencing. And when we looked at all of the really, really high departure rates, especially for these true zero cases, those were really significant. And so it seems that it is an important factor. And it also, by us putting the sentence in about that it can support, I don't think we're going against case law. It's what the commission's intent is, the guidelines, and that it seems that this is one that can go for either one, just like there's other factors like remorse and some of those that are applicable to either type of departure. And this seems to fall into that category. And again, it's not, it's a factor. The court doesn't have to give the departure, but it is available as a legitimate departure if they decide to, or factor if they decide to do that.
Or more.
Well, this is a challenge for me because I totally understand what Judge Knutson was getting at in district court. I mean, I can't sit here and say that every sentencing decision I made adhered to the four corners of each nook and cranny of the sentencing guidelines, and there was some blurring of the lines here. But to put this in print like this, I have a lot of the same concerns that I think Commissioner Frase mentioned and Commissioner Ladd. I mean, there is case law that makes, I think, it pretty clear that the courts have rejected the lack of a criminal record as being as appropriate basis for a downward durational departure, because I guess the theory is that that lack of a record is already factored into the presumptive sentence based on the other factors of the guidelines. And so I don't know. I just feel like this is sort of the camel's nose in the tent here. I mean, we're rejecting the bigger push that was made for, looking at rejecting the whole underlying basis for the durational and dispositional departure distinction, and then adding this in the back door. And I don't know. I think this runs the risk of confusing district courts and potentially, it'd be interesting to see what the Court of Appeals would do this with, given the law on this. I mean, if this is justified here, I'm pretty much where Commissioner Ladd is here right now. I don't know if there's another way to talk about this, but putting this language in the guidelines here, I think is just problematic under the status of our existing law, is at least I read it.
I guess the question that I would have for you is, if you wouldn't mind responding to a question.
Sure.
What is the role of the commission's intent? I mean, usually when, for any other provision of the guidelines, if it was unclear what should happen in a particular case, the Court of Appeals, the Supreme Court would be interpreting the language and would be looking to commission intent as part of that interpretation. So what's to prevent the commission from clearly stating its intent for how a particular provision should operate? And why wouldn't this be a case where we could do that?
Well, I don't think the commission's prohibited from stating its intent. I mean, I don't mean to be suggesting that. I just don't agree with this particular statement of intent, if that's what it comes out to be. And I say that somewhat because of, institutional concerns. I mean, there's a lot of ground that's been plowed on this. I think Justice Amdahl did it initially, but, right in the start of the interpretation of the guidelines. And, I understand the concerns that the chair is raising here. I think the statute expressly grants the commission the ability to express its intent regarding the guidelines. And so I'm not here to say that couldn't happen, but I just caution against this particular expression of intent, which appears to go directly contrary to what the guidelines have been interpreted as by the courts. And this is where there's obviously some tension, and, commission's views changed, or if the commission doesn't view the court's interpretation as accurate, that's a different issue. But I just think we need to think about what we're saying here as a statement of intent. Maybe there's another way it could be characterized. I don't know.
And the one thing I'll continue. The one thing I would say too is I just want to remind everybody that this is not a sentence added onto an existing factor. It's a sentence added onto a factor that we are adding. So the whole thing should have been underlined. Is my point. The whole thing should be underlined because this doesn't exist. And I think I would feel that way if we were adding that sentence to something else. Then I think you're right. We're expressly saying this case law doesn't apply, but this is one where case law has not been applied yet because it hasn't been used. It hasn't been interpreted. It's not even in effect. So to me, that felt like a different situation where we had the ability to state our intent from the beginning that this factor is different than other factors that might be in there in the guidelines now today. Commissioner Larkin, and then Commissioner Middlebrook.
Another thing to think about here, as Professor Fraze pointed out, this does sort of like go to that offender offense distinction. And the case law certainly says you can't rely on lack of criminal history because that's already factored in. But the one point I'd raise there is this started as something called the true zero. So it wasn't really like, this isn't meant to be criminal history score of 0. We talked in the small group about there being a true 0 versus a person who has criminal history score of 0. And that perhaps the true 0 should somehow be put in the grid so that person who's never before had any criminal conviction, stay of adjudication, would be treated differently than somebody who has things, but not enough to get to a point. So in that sense, it's a little bit different than criminal history score. Criminal history is already factored in. And I think at one point, Judge Knudsen said, what's this true 0? What does that mean? And we didn't like that phrase. So then we were like, well, let's spell out what we mean. I mean, maybe that phrase true 0 is something that distinguishes this from case law saying criminal history score is already factored in. Especially if you say true 0, we don't mean someone with a 0 criminal history score. We mean a true 0. I don't know if that's helpful, but to me, that is a little bit of a distinction.
Commissioner Middlebrook.
Thank you, Madam Chair. Actually, I was going to say the exact same thing as Commissioner Larkin about what happened at the steering committee. And I just wanted to clarify that this really isn't, this isn't really backdooring anything because we had both this proposal and also the other one about, that the departure factors could go to either durational or dispositional that we're putting basically on hold. These were two separate ones. And this one came out of, yeah, we had a really, really lengthy discussion about the true zeros. And also we even looked at revising the grid to put a true zero column in. And we decided that that was getting a little bit too complicated. So then we went with this as a departure factor, and all had consensus on it when we came out of the committee. So I just wanted to clarify that, but I think Commissioner Larkin had kind of explained more about what this means with the true zero.
Commissioner Mueller.
Excuse me, to Commissioner Ladd's point, would there be more clarification if we follow through with this whole study and tracing each case back? Like you said, that would take have time and that, but would that give clarification to some of the questions being raised here? Maybe Commissioner Ladd can answer that.
I think that goes to the question of the other concepts of, whether we wanted to put something in the guidelines to say it's our intent that any of these factors could apply in either. That's a bigger change. And so I think for sure we would need to do the full case law analysis to to get any level of comfort with making that kind of decision and figuring out what the real ramifications of that would be. I don't think that would change this just because this is, a new factor that really has not been included in that case. Commissioner Price?
Well, just to clarify, I support this with or without any changes in the underlined language. I think Commissioner Larkin made a compelling point. This is not a criminal history score factor. It's something within one of the categories. And, I would have strongly supported a true zero column on the grid. I'm not sure that really is any more complicated. The value of this, though, and maybe you could say it's a small step, it's a first step, see how judges use it. Going back to what I said about reduced culpability and reduced risk, maybe those aren't always true. So by making it a downward departure factor, we give judges the power to recognize, mostly these people are less culpable and less risky, but not this person, not this crime.
So what is the will of the commission? I think our choices are to support the change or not support the change. That if we don't support the change, this factor is still in the package. So we would be coming back to it. We don't have to approve or deny the factor at this point. Not hearing anything either direction. So we would need a motion if we wanted to amend this language. That's just to be clear. If we want to amend it, we need a motion. If not, then.
So how, this in qualifying cases, someone proposed to delete that. Maybe it goes without saying, there has to be compelling, substantial compelling circumstances. I will move that without that language, we add the rest of the underlying language.
Commissioner Price moves adoption of language. Do we have a second? Second by Chris. Discussion on the motion? Commissioner Larkin.
I don't oppose the notion that this new factor should be able to support either. I think that's what the intent and what people are agreeable to. What I'm hearing is that line is going to raise all kinds of questions because a defense attorney is going to be saying, my client's never had anything before. I want a durational departure. And a prosecutor is going to say, I'm just thinking out loud, well, you can't read the rule that way because we've got all this case law that says you can't rely on an offender factor, and the fact that he doesn't have anything at all is an offended fact. So it's going to raise issues, certainly. Why I said maybe we should have a comment. I mean, perhaps the cleaner thing is just to put the factor out there without saying it can go either way, and then have that leg be part of next year's discussion about the bigger picture of offender offense factors. It's a hard question. I mean, me personally, I don't have a problem with the notion of, well, because this is what Judge Knudsen was saying, you know, I'm gonna send this person to prison. I'd really like to have a reason to shave off some time. And if it's somebody who's never been in trouble before for anything, he said in his mind, that would be a reason to do it. So I can get behind that. But I'm also concerned about injecting uncertainty and having to litigate this. And what will come of it when people start saying, well, wait a minute, this is inconsistent with the case law. And if we don't have any comments saying, well, we recognize that, but we're going to do it anyway, I think it's not going to get you where you want to be.
Thank you, Madam Chair. Well, I disagree that I think putting this in here clarifies it and gives the direction needed, that it won't be that litigation, because that clarifies. And I think that our comment can also provide more about basically the true zero and why this supports either one. And I think that's what, you know, we're talking about, doing the comment, not omitting a comment, but working on that language going forward to explain it.
So, Larkin, my question to you would be, if we were able to draft the comment now in the court, would that concern?
What?
Do you feel like you would need to comment?
I am just being persuaded that it does raise the bigger issue, which we're tabling. So if we just did this without the new language and save the new language part for next year when we're talking bigger issue, that would be a safer way to do it. I think that's what Commissioner Ladd was suggesting. Commissioner Ladd, is that your thought?
Sorry, I was having technology problems. Yeah, I mean, again, I appreciate this discussion, and frankly, I will tell you, and I appreciate Professor Fraze's comment. I'm now regretting or having some remorse about the true zero grid piece of it, and I think part of that, it did get to be a little bit complicated when we were working with layouts and such. I just struggle with this, and I think it does create. It creates, from my perspective, it does create sort of a slippery slope into the very issues that we're concerned about with the bigger proposal. And I think that's the issue for me.
I'm sorry.
That's okay. So Commissioner Ladd, you're thinking, if we're being intellectually honest, maybe we just go back to considering that first column, true zero, which was where we started with this and then sort of ended up here. Because then that does reduce the duration. Because we don't really, this is for durational departures. You can get to a dispositional departure without this new factor pretty easily. So if this is about durational departures, maybe, you just put that column in, choose 0, and that's a lower number, up and down. And then you don't run into these other thorny legal issues.
Or,
Madam Chair, oh, sorry.
oh, sorry. You want to respond to that, Commissioner Ladd?
Yeah, I was just going to say, yeah, and I've thought about that a lot. And to Commissioner Larkin's point, I do think that it does take off some of the other, for lack of a better word, thorny issues that we're sort of trying to navigate around here. And again, I know part of what we were trying to do in all this is to keep things simple, not make things complicated. And that, that extra column in the grid, or even if it was its own little by itself grid and what have you, I do think that that would eliminate some of what we're concerned, at least what I'm concerned about here, because Judge Larkin's right. I mean, the dispositional departure is not really what we're talking about here. We're talking about the durational piece, and that was all of the examples, I think, when we were having some really robust discussions about this that Judge Knudsen was talking about. And I was relating to exactly what he was saying, and so I think that is the issue. It's the durational piece of this.
Commissioner Moore?
I agree. The discussion here has been really helpful. For those of us who weren't on the subcommittee and weren't in the weeds on this, I think it would be, Commissioner Larkin characterized it as intellectually honest. I think it would be helpful and maybe more just transparent for us to just say that. I mean, to create a true 0 column in the grid. And if this factor is applying specifically to that, I think that does go a long ways to alleviating my concerns about saying something that's going to be, as Commissioner Larkin indicated, used for other attacks on things like the guidelines and sentencing laws. So I think, I don't know how complex that would look, but that to me is something that I think I could get behind, actually. And it would alleviate my concerns about this, or it would help explain why this proposal is.
Yeah, do you want?
Yeah.
We're still on discussion on the motion, but yes.
Can we see the grid, the standard grid? And keep in mind, this is not meant to change anything at 10 or 11. So those 2 boxes stay as they are. It's not going to do anything through 1 through 4. You really,
I'm sorry. Why would it do anything from 1 through 7? Criminal history.
It still reduces the length. So even if you're staying execution, you're saying 30 months instead of 36 months. Commissioner Middlebrook?
Well, I disagree that it doesn't do anything there. It does, because and we see these come through, particularly on these true 0 cases where the judge will sentence them to a gross misdemeanor sentence to keep them out of felony, but that's considered a durational departure. And that's what we see a fair number of these true 0 cases doing to try to help them keep jobs, even not have a felony on their record. And that was actually one of the examples I think Judge Knudsen brought up too. So that's why any of those they would all be in that category.
so we would have gross misdemeanors on the grid now? Gross misdemeanor
that was-
sentences?
I mean, that's what we ran into when we were talking through that column.
Yeah, whether there's a way to provide a discount for the folks who are at a year and a day.
That's partly why we went with this factor instead, because that was getting maybe less than
Commissioner.
Madam Brown.
You're live, go ahead.
I'm sorry, did you say me?
Yes, I did.
Okay, thank you. Didn't we have, maybe I'm not seeing it here on my screen, but I thought we actually had like a template grid that we actually had a little column that had the little true zero thing in it that showed numbers. I'm just seeing the normal grid here, so maybe I'm looking at the, maybe I'm not understanding what's being displayed. But when in our steering committee, we actually had an example of what the grid would look like with that extra column.
Yeah, we did, and that's what Commissioner Middlebrook is raising right now is that in order to provide that discount at every level, except the ones at the top that we had excluded, that meant that some of those scores had to go, or some of those durations had to go below a felony sentence. So at severity level 1, it's currently 12 months, maybe it'd be 9 months instead, and then that makes it a gross misdemeanor. And so that was some of the discussion and the sticking point, one of the sticking points in the steering committee. Commissioner Larkin.
Thank you, Madam Chair. In the big picture, my recollection of Judge Knudsen's suggestion and this whole topic was, what do you do when you have somebody that you have to send to prison on the grid, but they absolutely have no history? So that's why I was looking at this and saying, well, we're really only talking about 8 and 9, because we're talking about people who are presumptive commit with 0. I never envisioned this as, well, people who are presumptive probation getting a reduction down to a gross misdemeanor. I thought this was about people who must be sent to prison, but you want to shave a few months off because they've never been in trouble before. And if that's what we were talking about, and I thought we were, then we really only have to do something at 8 and 9.
That was my understanding as well, and so I might have misunderstood as well, but that was my understanding.
I don't recall a discussion about, well, we're going to give this break to people that have a 0 and who are facing probation. It was for people who have to go to prison very first time they come to court.
I mean, that was the thrust of the concern, certainly.
And if then it really is just a matter, it's not even a whole column, it's just 2. 10 and 11 are out, and 8 and 9.
Yeah, just from a data point of view, one of the most common mitigated departures that we see is a mitigated durational departure to less than 12 months. So the defendant gets a gross misdemeanor sentence and therefore is not guilty of a felony by operation of that departure. And that honestly is one of the problems with the offender-related factors can only support dispositional departure, because that's a durational departure, and yet I think a lot of times judges make that decision very much based on the defendant and defendant's needs and the defendant's history and so forth, which is also borne out by the data. About 15% of departures, durational departures, are based on offender-related characteristics, case law notwithstanding.
All right. All right. So we do have a motion on the table that we do need to address. I think that, one thing that I do want to say is I don't think the larger package will make it through unless we have consensus on it. So I am really reticent to get less than a full support for any particular proposal. And so this one concerns me from that perspective. I think, like, talking about the true zero concept, it is good to hear the support for the concept here, but it's a complex policy that, to put into place. Like we could definitely work on it if people wanted to explore that, at like the November meeting, we could potentially forward, but I do think it is maybe a either or, it's either this or that. So I guess I'm sort of, to me, it feels like a big lift in the amount of time that we have to do that, but we certainly can go that direction. So I guess I'm sort of wondering where we want to go with this particular proposal, and do we move forward with this vote and see how it goes, or do we withdraw the motion and move on to considering the full package? Commissioner Larkin?
And just to be clear, the full package contains, and as it was up there, just without the new
Just
language.
without the new language.
Are people comfortable with that? Is it just this last line that raises this offender offense dichotomy that gives us pause?
Based on your comments, I'm asking, I do not want to derail our whole thing and spend any more time on this. So if it would be helpful, I would withdraw my motion or turn it around and say I move that we adopt the language without the new language, that we not add the new language.
I think you could, probably withdrawing it would be appropriate, because we'll look at the whole together in a few minutes.
I request to withdraw.
Agenda item. So you're withdrawing your motion?
Yes.
And I forgot who seconded that. Commissioner Mazzaros, are you okay with withdrawing? So we will not look at adding that language for now. Let's move on to the full package, which is item number 5 on our agenda. So we'll ask Director Wrights to move it.
Thank you, Madam Chair. I'm going to start with document 5A, which is a description of the consensus policy package. I've rearranged the policy package in a way that I hope will be easier for the public and for the legislature to grasp, and maybe for the commission as well, to grasp. So I divided it up into the main 2 categories are A and B. A has to do with changes to how criminal history score is calculated, and B has to do with offense severity. And because those are the 2 main components of the criminal history of the presumptive sentence calculation, I think it fits really well. So and it also fits well because zeroing in. So I do have an introduction there that talks about this as being a whole consensus package that the commission and the steering committee took as a package, mindful of the changes, various impacts. Which is to say that, like any compromise policy package, not everybody got everything they want, but as a package, the commission was satisfied with it as a whole. So starting in A with changes to criminal history score calculation, this has really been reorganized by the 4 components of criminal history score as they appear in the sentencing guidelines: felonies, custody status, misdemeanors and gross misdemeanors, and juveniles. And those are the 4 areas where we now get points from. So the big change for A, prior felonies, is reducing the decay period. So it basically describes how decay works. Right now, the rule is if a prior felony sentence that has reached its expiration or discharge date is no longer included in criminal history calculation if 15 years after the date of expiration of the prior prison sentence, or if there was no prison 15 years after the prior sentencing date. The proposal is simply to reduce that decay period from 15 to 10 years. A2 moves to the second component, custody status at the time of the offense. And this is described as converting it to a durational modifier. The term modifier is used in a different context in the sentencing guidelines, and I should say the text does not literally describe this as a modifier. It describes it as a durational increase. I'm calling it a modifier because I think that'll be easier for our audience to understand. That's functionally something that practitioners are used to, so that's why I'm putting it in the description, but I just want to make it clear that this is not language that's actually going to appear in the guidelines. So instead of being a factor that will move the defendant across the grid, it will instead increase the defendant's duration. Now, the duration increase in most cases will be equivalent to having moved across the grid 1 square. But the key difference is it will never cross the dispositional line. So a defendant who wasn't going to go to prison without custody status will not go to prison because of custody status if this goes through. That's the big change. Another difference that I don't highlight in this description, well, I do, I say for some with very high criminal history scores sentenced for serious offenses, the recommendation will actually be greater than the duration now recommended. That's because the current rule is a blanket 3-month bump. If you are in the farthest right column and you have custody status, you basically get 3 months added to your sentence. Under the new rule, you're going to get as much of an increase as you would if you moved a row to the right, even if you're already in the farthest right column. So you're actually going to get much more than a 3-month bump. Subject, of course, to the statutory maximum, which will probably come into play here. But the recommended durations will be significantly higher for defendants with very high criminal history scores sentenced for very serious offenses. I just want to park a little bit on that second paragraph there. So there's been 2 recent appellate court decisions regarding custody status just in the last, I would say 3 years. It's in the footnote, but so you can fact check me there. But and this proposal sort of incorporates those decisions in the status quo. The first decision, the proposal disregards custody status arising from misdemeanors, gross misdemeanors, and low-level felonies, and that's consistent with a case called Bogdanovich. And then the second decision is that the proposal implicitly includes custody status arising from stay of adjudication probation, and that's from a case called Woolridge Carter. And that was, I'm not going to editorialize and say whether or not the commission intended for those results to be, but that's how the case law is now. And it was the steering committee's decision to just incorporate the status quo into the language. So that is incorporated.
Commissioner Larkin?
Can you explain the proposal disregards custody status arising from misdemeanors, gross misdemeanors, and low-level felonies? In our current definition of custody status, do we not include misdemeanors, gross misdemeanors, or low-level felonies?
So currently the misdemeanors, gross misdemeanors, and low-level felonies get a half a point.
Oh, that's how you're getting there.
But Bogdanovich said half a points don't, to oversimplify it a little bit, Bogdanovich said you can't move across the grid with a half a point. So this simply disregards misdemeanors, gross misdemeanors, and low-level felonies, consistent with Bogdanovich's.
If the offense that you were on custody status for was a misdemeanor, level 1 felony, custody status. Right. So it's the same as the way it's operating today.
And we're, as part of the big package, we're not going to count misdemeanors anymore, right?
No, we are.
We are.
Yeah, but
Targeted.
only for their history, not for their custody status.
Well, here's my concern. What if there is somebody that has the requisite number of misdemeanors to get them to a line? Is that possible?
Sure. And I'll get to
But this
misdemeanors
is
in-
just tied to the offense, not the complete history. Okay.
Yep, correct. The offense for which they were currently on custody. So if they were on probation for a misdemeanor felony, won't get a custody status enhancement because of being on.
So so that's A2, and then A3, there's really two different policies at work, so I'm calling it A3A and A3B, but they both have to do with the third component of the criminal history score, which is prior misdemeanors and gross misdemeanors. Again, we're talking about the convictions, not the fact of the custody status. That's all rolled up in A2. So the first decision is to reduce the decay period. And that reduction is from 10 to 7 years, and that's approximately consistent. I have the math in the footnote, but one is like 30% reduction, one is a 33% reduction. So it's a very similar reduction from 15 to 10 years for felonies. There's a commensurate reduction from 10 to 7 years for misdemeanors. The other has to do with some rules that really had more of an impact back when felony DWI was fresh, and you'd find defendants with just really, really long DWI, misdemeanor, gross misdemeanor DWI records. And you don't see that anymore because people now have felony DWI records. So they're probably going to prison pretty quickly if they have very long records like that. But back in the day, people would have, I remember cases with 14 prior misdemeanor, gross misdemeanor DWIs. And there was a special 2-unit no limit rule. That rule literally isn't used anymore. So and it really complicates things. There's another complicated rule in 2B6, which has a special rule regarding felony enhancement due to a prior misdemeanor or gross misdemeanor DWI conviction, which is very complicated. And basically the proposal here is to just get rid of all these special rules for DWIs, treat prior DWIs just like any other element of criminal history. So getting rid of the 2-unit no limit rule. So DWIs are just treated like other targeted misdemeanors, or if applicable, gross misdemeanors, and they will each contribute 1 unit for a total of 1 possible point. And so 2B6, guidelines 2B6 is a lot of that really has to do with misdemeanors and how they're counted. So merging 2B6 into 2B3 and shortening and simplifying that language. So that's A3. And finally, we get to A4, finally under the criminal history proposal. We get to A4, which is prior juvenile adjudications. We've seen data where juvenile adjudications are pretty rare. If you add up everybody's criminal history score in Minnesota, they make up a small percentage, low single digits of percentages of the total criminal history score that everybody has in Minnesota if you added them all up. The proposal is to simply eliminate juvenile points from criminal history score. It's important to keep in mind that convictions resulting from extended juvenile jurisdiction juvenile cases or adult certification proceedings will continue to count among the adult felony. So those already are in the adult felony section. Those will continue to be in the adult felony section. Those are for cases where the juvenile case, in most cases, the juvenile case was a presumptive commit. So something like your armed robbery would probably be an EJJ case, or it would qualify to be an EJJ case as well as a juvenile case. So that's the end of section A, which has to do with the horizontal axis of the sentencing guidelines grids, which is criminal history. Now there are changes to offense severity, which is represented by the vertical axis. The commission ranks basically explains how the commission took this exercise and looked at these different offense groups. And the 2 offense groups where the commission decided to take action on making ranking changes was the one group that was related to vehicular behavior and the other group that was related to assaults. So I'm going to reorganize these basically from for the increased rankings first, and then the substitution of the modifier and the decreased ranking coming at the end. And I've got these arranged in severity level order. So the first change is to increase the ranking of assault in the 2nd degree where substantial bodily harm was inflicted from severity level 6 to severity level 7. Currently, the guidelines make no distinction between assault in the second degree with a dangerous weapon, where substantial bodily harm was inflicted and where substantial bodily harm was not inflicted. So now if there was no substantial bodily harm, it will remain at severity level 6. If substantial bodily harm was inflicted, it will increase to severity level 7. The second increase is in criminal vehicular operation resulting in great bodily harm. The commission only wanted to increase the rankings where there was gross negligence or where the defendant was impaired. So while impaired is a shorthand for the probably 5 different provisions in the law where the defendant was driving negligently and under the influence of alcohol or had a certain alcohol level in the defendant's body or had other controlled substances. So there's quite a few ways of getting there, but basically I'm calling them while impaired because it's the same list that applies to DWI. So it's essentially makes you DWI. So I'm just taking off the D and calling it while impaired. So for a grossly negligent or impaired driver who causes great bodily harm, the commission proposes increasing the severity level from severity level 5 to severity level 6, which is where fleeing a peace officer resulting in great bodily harm is also ranked. The commission is not proposing to change the ranking of criminal vehicular operation resulting in great bodily harm involving leaving the scene or defective vehicle maintenance. So those will stay ranked at severity level 5 where they are. B3, this is 2 offenses that are being increased in ranking from severity level 4 to severity level 5, both in the assault category. The commission proposes to increase the rankings of 3rd degree assault resulting in substantial bodily harm from severity level 4 to severity level 5. Also domestic assault by strangulation from severity level 4 to severity level 5. 3rd degree assaults involving child abuse rather than substantial bodily harm, severity level 4. And then the final increase in rankings would be assault in the 4th degree. So there are a number of gross misdemeanors under the assault in the 4th degree. Assault in the 4th degree typically involves a special victim. So it could be a peace officer, it could be a correctional employee, somebody who's probably engaging with the defendant in some way as part of the law enforcement system or as part of being a first responder. And the statute generally defines these assaults as gross misdemeanors, but many of the provisions become felonies either when demonstrable bodily harm is inflicted or when bodily fluids or feces are weaponized. So that's where we get to the felony level. In the case of assaults motivated by bias, if the offense occurs within 5 years of a prior assault motivated by bias, that's how that becomes a felony. And all these are currently ranked at severity level 1. The commission proposes to increase these by 2 severity levels to severity level 3. Then we get to, it looks like an increased ranking, but it's kind of a lateral move in my view. It does simplify the guidelines, so I certainly like that, but it's replacing a sentencing modifier with an increased ranking. So currently, criminal vehicular homicide is ranked at severity level 8. If there's a qualified prior driving offense, so a qualified prior driving offense is a 1st or 2nd degree DWI, criminal vehicular homicide while impaired, or criminal vehicular operation while impaired, the statutory maximum penalty increases from 10 to 15 years. I just want to talk a little bit about qualified prior driving offenses and what I think the legislature might have had in mind in defining that list. So if you have that as your record, you have a 1st or 2nd degree DWI or a criminal vehicular homicide or a criminal vehicular operation while impaired, and you commit a new DWI, you're guilty of a felony DWI. Your new offense is going to be a felony DWI. So essentially what they're saying is if the current offense is a felony DWI and you kill somebody as part of a felony DWI, the legislature is increasing the statutory maximum by 50%. And the commission has that ranked at severity level 8, but increases the, has a 50% modifier. so that the duration will go up by 50%. The commission is changing that to an increased severity level ranking at severity level 9, which ends up with pretty similar durations. Some are higher, some are lower than the 50% modifier, but I think it's also clearer to the reader that that's ranked at severity level 9. I think that'll be easier to implement. We see low use of this modifier, and I wonder if it isn't because it's a little confusing. So this should make things a little more simple, I should say. And finally, we have the only reduction in ranking, and that's reducing ranking from severity level 9 to severity level 8. Assault in the first degree resulting in great bodily harm. Assault resulted in great bodily harm. Currently, it's ranked at severity level 9, and the commission proposes to reduce the severity of this to severity level 8. And this is paired with a legislative recommendation to create a new crime that will be ranked at severity level 9. And wasn't intending to discuss legislative recommendations at this time, but I think it's important to keep that in mind, that there would be a new severity level 9 crime that would be the intentional infliction of great bodily harm rather than an assault that merely results in great bodily harm. So that's A and B. So you got the criminal history and the offense severity. And then we move on to C, which is other changes. C1 is clarifying the guidelines, purpose and principles. This should be fairly fresh in your memory since we just discussed this last month's meeting. Changes include defining what is meant by public safety, an explanation of proportionate sentence severity, and a discussion of the purpose of the criminal history score. C2 is clarifying the burden of proving out-of-state offenses. Commissioner Ladd kindly pointed out to me that the word county in that description should be count, but the commission proposes to clarify that the burden to prove whether or how to count out-of-state offenses in criminal history is the prosecutors, not the probation officers. And C3 is displaying ranges in the shaded cells. Currently, they're not displayed where prison is ordinarily not presumed, but the commission proposes to display the full range in all grid cells. That'll be useful for those cases where that actually is a prison commit. For example, if there's a mandatory minimum that applies, judges don't really know what the range is unless they do the math. I'll just leave that at there. So it can be dicey, let's put it that way, to do math on the fly for anybody, not just judges. So that'll be displayed. I think that should be helpful. The commission also proposes to revise the example offenses on the grid to be more representative of the offenses sentenced at that severity level. I just want to pause here and say one thing about that. Actually, I should have paused earlier with B, but let me pause here and say that the example offenses on the grids that are on pages 28 through 32 of the text of September consensus policy package, those are different offenses because it's now taking into account these ranking changes that you made. So the ranking changes actually resulted in the need to change the example offenses. So that's going to be new when you see that. And one thing I wanted to say on the ranking changes that's also new that the commission hadn't discussed, and that is something that I inferred. And if I'm wrong, you can stop me. But the legislature has always ranked offenses involving assaults or the death of an unborn child, including criminal vehicular operation resulting in either the death of an unborn child or great bodily harm to an unborn child who's born alive, but has experienced great bodily harm as a result of the driving behavior, the defendant's driving behavior. The legislature has always assigned those offenses the same statutory maximum penalty as they have for the parallel offense involving a person. And so the commission, is taking the legislature's cue, has always ranked the two different offenses, the two different versions of the offense equally. So criminal vehicular homicide is ranked the same as criminal vehicular operation involving the death of an unborn child. So I assumed that the commission wants to continue that practice. And so all the ranking changes that are made in the text of the document treat assault offenses, for example, involving substantial bodily harm or great bodily harm, or criminal vehicular operation offenses involving substantial bodily harm, great bodily harm, or death. Treats those, they all move the same. So if it's going up for one, it will go up for the unborn child as well. Does that make sense? So I just want to be clear. I'm not trying to hide the ball or anything. That's just been the normal practice of the commission, and we implement that there. And one of the reasons we don't really discuss that is because there's a vanishingly small number of those cases. You very rarely see those cases, but the commission and the legislature have traditionally kept them in lockstep as far as sentencing go. Moving on to C4, we have the new departure factor, true first offender. The text is reproduced here. That should look pretty familiar since you've had an opportunity to look at that text for most of the meeting so far. So that summarizes document 5A. And then we have document 5B, which is the text. I'm not going to go through the text at this time, other than to point out one error. And that is in the very last page, page 44. So this is definitely a beefy package. But on page 44, this is appendix 3. The appendices really aren't part of the guidelines. They're kind of like the commentary. At least that's my understanding of it. But they're supposed to be helpful documents for the commission or for practitioners. So the third line from the bottom, pertaining to assault in the 4th degree of a corrections employee, prosecutor, judge, probation officer, secure treatment facility personnel. It says that it maxes out basically the current 24-month statutory maximum into the grid time at criminal history score of 6 upper range. That actually should be criminal history score of 5 upper range. I'm saying just a little bit before that. And that's one of the reasons for the legislative recommendation to change that, which we'll get to in a minute. So I don't have any intention of walking through the text, but certainly if there's any questions about the text, we could address those at this time.
Very lad.
I had a couple of questions regarding the grid example offenses and just wondering if you could go up to the standard grid.
Sure.
Actually, I had three questions.
Give me a page number. Oh, wait.
Oh.
I think I've got it.
Sorry.
Okay.
Okay, so on the severity level, severity level 8, it says aggravated robbery, 1st degree, and then it says 1st degree assault, and then it says, is it assault 1st degree? Is that what that's supposed to be? That's the offense, the second one?
That is what that's supposed to be, correct.
Okay, and then at severity level 3 on that same grid, the offense example is vehicle use without consent. Is that theft of a motor vehicle?
No, that's 60952 subdivision 2A17. So it's the joyriding, basically. It's
Okay.
It used to be called unauthorized use of a motor vehicle, usually, but it's the one where the vehicle is taken but not with intent to permanently deprive the owner.
Okay.
So
And then on the, sorry,
if it's
go ahead.
permanent theft, if it's permanent theft, it's severity level 4.
Sure.
And I selected that offense because it's one of the more common severity level 3.
And then on the drug grid for the D5 offense, since that's the only offense that's in that category, it seems weird to me that it says possess meth precursors with intent, like possessing the precursors intentionally or intentionally possessing them to manufacture. So I know you're trying to shorten it up, but I sort of felt like it was a little confusing about what that actually meant, and it's the only offense that's in that category, so I just didn't know why we were making a change to the whole thing.
Well, I've been trying to get things down to 2 lines,
Okay.
so that's why, but,
Well, if we just, with intent to manufacture, and we did MFG for shortening up manufacture, would that help?
that might fit. Yeah, I could check that out.
Yeah, it just seems like it's like the intention is to possess, if you look at it quickly, the intention to just possess the precursors, or the intention to possess it to do something with it, where it's how it's phrased without all the extra language in there. So that was the only questions I had. Thank you.
Yeah, I think I could definitely fit in some abbreviation of manufacture in there.
And that makes sense. Okay. Other comments, questions? I have Commissioner Larkin.
I have just a comment. Sorry, it's going to be long. Okay, I just want to be clear what we're doing and make sure everybody understands, because I'm still thrown by this, going back to the custody status, you know, what we're doing is what the Court of Appeals said to do in Bogdanovic. How do I approach this? Okay, so there was a time when whatever felony you were on probation for counted in some way towards custody status. And then there was a change to say, well, these lower level felonies should be given a half custody point instead of a full custody point. That led to problems because in the rules we had, or in the guidelines, a guideline that said if your criminal history score includes a half point, you round down. But we didn't have a similar rule saying, what do you do if you end up with a partial point in your criminal history score as a result of custody status? And so that was creating a world of problems. The Court of Appeals had a non-precedential decision in which I just read, and Eugene, which said, okay, well, this guy's only got a half a point for his felony criminal history portion of his score. So that rounds down to 0. That leaves him with just a half a point for custody status. That also rounds down to 0. With really no analysis whatsoever, just said that rounds down to 0 in a non-precedential case. Then we, in Blagojevich, a precedential case, well, there was a non-precedential decision. Then we issued guidance saying for now, and just do what they did in Eugene, which is if you end up with just a half point based on your custody point, you don't count it. After that, our court issued published decision, Blagojevich, which said, well, this is the guidelines, the sentencing guidelines has given us. We're adopting that. So henceforth, if you have a half custody point, it doesn't count towards anything. So that's where we get to this statement that what we're doing here is consistent with Bogdanovic. It is, because you got the half point at a level 1 or 2 on the grid. So to say, well, level 1 or 2 would have gotten you a half point. Court of Appeals says that doesn't count. So we're not going to give you any custody status at level 1 or 2. The thing that makes me a little uncomfortable is, you know, we get to that Court of Appeals case, not because of any policy decision of this body, but because the Court of Appeals was making the most sense out of what it had before it. And I just think we should be clear, because I know that Judge Knutson is no longer with us, but he was very firm in that, you know, custody status should count for something. And what we're doing now is saying there is no custody consequence if your offense of probation or your custody status is a felony level 1 or 2. And if we want to say that, I think we should say it as a matter of policy. This group believes that if you commit a new offense and you're on probation and it's only a level 1 or 2 felony that you're on probation for, we're not gonna hold that against you. And we should just say that as a matter of policy, as opposed to sort of this roundabout way saying, well, we're doing that because that's what the Court of Appeals said, when in fact, the Court of Appeals said that based on guidance from this commission. So that's just what's not sitting well with me. We should be transparent. Does that make sense? That's my concern, at least.
So revise the explanation.
Well, I guess what I'm saying is, do we all agree that there should be no custody consequence if the felony offense for which you're on probation is only a level 1 or 2 offense? And I don't know that we talked about it that way, and maybe we have, we've talked about so much, that's what gave me pause, is a suggestion that, well, we're doing this because this is what the Court of Appeals said to do. Well, that decision was in a very unique set of circumstances. And I think if we're going to make that change, I mean, what I would say is that whole half-point custody status snafu, even with the half point, this body at that time was saying there should be a consequence, a custody consequence for a level 1 or a level 2 felony probationary offense. And now we're saying there's not. Is that what we want to do? That's all I'm raising.
And I think that, oh, go ahead, Pastor.
So that Eugene's decision obviously never made sense. Round down the total, round down each one.
I wasn't on the panel.
That aside, I do think that we should have a consequence for somebody who's in custody, who's on probation for level 1.
Commissioner Middlebrook.
Thank you, Madam Chair. I mean, part of the reason that we were trying to get rid of the half point because everybody that was, part of the survey, and I think when the judges came back from getting input, that was one of the top things, get rid of this half point situation. The half point came up back because people were getting more time for the custody than what the underlying crime, like for a misdemeanor, they were getting more time on the custody